All right. Good morning. Aloha kako, everyone. This is the January 7th, 2026 Land Use Commission meeting. This is a hybrid meeting, which is being held at the Leopapa Kamehameha State Office Tower at 235 South Beretania Street, room 406, Honolulu, Hawaii 96813. This meeting is open to the public. For all meeting participants, we'd like to stress the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, please state your name and identify yourself for the record. This is a hybrid meeting, so please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting, which will be posted to YouTube and used for court reporting purposes. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit this meeting now. Please note that the question and answer feature on Zoom will only be monitored for signing up for public testimony, and all other communications will not be addressed or part of the meeting record. Communications can be emailed to our office at dbedt.luc.web@hawaii.gov. We'll also share with all participants that we are planning on taking breaks from time to time, perhaps every 60 minutes. For the commissioners participating via Zoom, please indicate where you are attending this meeting and if there was anyone else over the age of 18 present with you if you are calling in remotely. All right, let's see. Again, for everyone, my name is Brian Lee and I will be serving as the LUC chair today. We currently have 9 seated commissioners, and along with me today are commissioners Ken Hayashida from Oahu, attending remotely. Mr. Hayashida, are you there with anyone else?
Nope, I'm in my office and I'm here alone.
Okay, thank you, Commissioner Hayashida. Mel Kahale is here with me in the room as. Thank you very much. And we have Kueke Okalani Kamakeo Hello attending remotely via Zoom. Commissioner Kamakeo Hello, are you by yourself?
Aloha, Chair and Commissioners. Happy New Year. I'm here at home, my home office, and I am attending alone by myself.
Thank you. And then here in person is Michael Yamane, Commissioner Yamane from Kauai, and Commissioner Dan Giovanni, also from Kauai. Here as well is Commissioner Bruce Uu from Maui, Commissioner Miles Miyasato from Hawaii Island, although I guess it's now Hawaii officially now. And also Nancy Carr-Smith attending remotely from Hawaii Island via Zoom. Commissioner Carr-Smith, who's also the vice chair, are you confirming you are by yourself?
Yes, I am, Chair. Good morning. Thank you.
Good morning. Thank you very much. Okay, everyone. Also in attendance in this room is the Land Use Commission Executive Officer Daniel Orodenker, LUC Chief Planner Scott Derrickson, LUC Staff Planner Martina Segura, LUC Chief Clerk Ariana Kwan, and LUC Deputy Attorney General John Dubiel. Again, court reporting transcriptions are being done from this Zoom recording. All right, agenda item number 2 is the overview on Land Use Commission administrative procedures. This overview is intended to provide training on Land Use Commission procedures related to annual reports, staff reports, site visits, agenda development, and website maintenance. We'll now recognize any written public testimony submitted in this manner. Ms. Kwan, has there been any written testimony submitted for this matter?
No, Mr. Chair.
Okay, are there any members of the public that wish to testify today on this matter?
Seeing none, using the Q&A feature, Chair.
Okay, thank you. Seeing none, then let's go with the presentation. Mr. Orodenker, please proceed with your presentation. But before you proceed, I have been notified that there's a requirement that all questions from commissioners be directed through the chair rather than addressed directly to staff due to an impending investigation. This directive applies to all the commissioners. Thank you very much. Okay, Mr. Orodenker.
Thank you, Mr. Chair. Before I begin, I would point out to the commissioners that excuse me, a lot of the information that I'm going to be providing is contained the training page, which is under the pull down for the commissioner's checkpoint. And it's also discussed in detail in our July 23rd and 24th meeting in 2024, which is the transcript is available for anyone who wants to review that. And there is a lot more information in there with regard to other issues as well. The first item that we were requested to discuss was the annual review report process, annual report review process. That process is designed to ensure that petitioners are adhering to the conditions contained in the relevant decisions and orders. Assuming we receive an annual report as required, they are accepted, file stamped, and posted to the website. Staff reviews them in light of the conditions contained in the decision and order to see if there is adherence to those conditions. And there are three possible outcomes from the review. One is that everything is fine and we simply file it and move on. The second one is that the annual report does not contain enough information for us to determine whether adherence has occurred, and we ask for further clarification. If this happens, we send out a letter to the petitioner with our concerns and give the petitioner the opportunity to correct the annual report and provide us the additional information that we notified them that was missing. If they do provide the information requested and it satisfies our concerns, then that is sort of the end of the story. Once again, we file it and we move on. If they do not respond in a manner that resolves our concerns, then we have the option of scheduling a status report hearing before the entire commission so that the petitioner can be questioned as to their adherence to the conditions. If the third potential outcome is that the annual report on its face shows a potential violation of conditions, and sometimes that's simply a time constraint. They were supposed to have started construction by a certain date, and the annual report indicates that they didn't, or they've changed the infrastructure plans in such a manner that it no longer conforms to the decision and order. In those cases, we schedule a status hearing, and then the commissioners are free to ask questions with regard to adherence or non-adherence and whether or not the petitioner intends to meet those conditions. It's not unusual if that occurs for petitioners to say, oh, we're going to come in with a motion to amend so that they can rectify the problem that way because circumstances have changed and perhaps the roadway that they were going to build is not feasible anymore, or they sounded like I went off. They can't make a connection to the sewer system in the manner that they had suggested or originally represented. And that's pretty much the process. I mean, I don't know if Martina has anything she wants to add or wants to go into any more detail, but that's pretty much what I have.
Yeah, so when we receive the annual reports, we'll get them via email or via mail. If we receive them via mail, we contact the petitioner to get them via email. And it's a whole process. We have to make sure they're ADA compliant. And when we're not, there's constant communication and flexibility with the petitioner to make sure that they provide that file in an ADA accessible format. And then we'll stamp it. You see the e-stamp on all the files that we get. And we then will send back that filing to the petitioner as a kind of like a acknowledgement of receipt. And then the review process starts from there. So that's it. And then you guys get the notifications monthly of the annual reports we received for the month at the end of the month.
I'll entertain any questions of the commissioners at this point from the commissioners.
Commissioners, any questions for Executive Officer or Denker?
Chair,
Commissioner Carr Smith.
Chair, can you please ask the executive officer? Once further clarification has been requested and the petitioner provides the information that was asked for, he said then it's just done and they move on. What about, do you let the petitioner know that they are now in good standing, so there's no question about that? And if not, why?
Yes, we do.
Do you have any further questions, Commissioner Carr Smith?
Well, let me clarify that. Okay, we notify the petitioner that we received their additional information. The same way we do with the initial annual report. If we still have problems, we send out another letter, but just like an annual report that initially meets qualifications, we don't usually send out a letter that says, thank you, we now have no more problems.
Oh, so that's, there's no confirmation that there is no problem.
Yeah, I mean, it's kind of understood that if we do have a problem, we'll let them know. But if there is no problem, then everything's fine.
Is there often, is there usually a problem or not a problem in your estimate?
But Ms. Segura, do you have a percentage?
I don't have a exact percentage, but it really depends on the docket and how many conditions are associated with the docket. There could be problems as simple as like there is a condition to transfer lands to the, say, like DOE, but there's been no follow through or like a record of that transfer on our end. But usually if it's like a record, sometimes we won't notify them of minor problems. Sometimes it really depends on the situation. Like if they're having ongoing building, then we kind of hands-on unless there's a specific like condition that's like a condition of concern. So like the damselfly condition at one of the petitions, and it really kind of
Well, that didn't arise from the annual report, but it's not a big percentage. It's a small percentage because, I mean, to be honest with you, a lot of the annual reports, because they have to list all the conditions in the annual report, just say, we intend to comply with this condition. It's only if they tell us they don't intend to comply, or that they have other plans, that there's a problem, and that doesn't happen very often. 9 times out of 10, if a petitioner doesn't intend to adhere to a condition, then they will tell us that they're going to file a motion to amend even before the annual report is due.
Thanks, that's very helpful. Any other questions for Executive Officer or Denker on the annual reports? So it's sort of a judgment call sometimes as you're interacting with some of these petitioners, how responsive they are and what your expectations can be for them.
Yes, that is correct. Most petitioners are fairly responsive with the annual reports. But once again, our goal is not to cause petitioners additional expense or kill projects. Our goal is to make sure that they don't get hit with a lawsuit from the community because they haven't adhered to a condition.
Does staffer Arnold Wong get involved in any of these annual report feedback or discussions?
Staff does. I mean, that's what we're here for. But Arnold's review of annual reports is a little bit different. He utilizes annual reports to determine whether there's anything out there that he can help fix. You know, for instance, if an annual report says we haven't started construction on the sewer line or the water line because DOT hasn't granted us an easement across the road, then that's something that keys in Arnold that he can get involved.
Thank you. Anybody else have any other questions? Okay, seeing none, thank you. Please proceed.
The next item is the LUC site visit policy. Site visits are scheduled prior to review of a new district boundary amendment. Or at the request of the commissioners via the chair. But we don't generally schedule site visits for motions or special permits. Site visits are sunshine law meetings, meaning they're noticed and the public is aware that they're going to occur. But they're designed for commissioner education. The public is not allowed to ask questions and there's no transcript of the minutes. And I usually explain that to the public before we begin. And one of the reasons that I caution the public that they're not allowed to ask questions is because there is no transcript and it won't become part of the record. We haven't had a new DBA in a long time, so we haven't scheduled many site visits. In juxtaposition to that is what we call staff site investigations, where we get notification from the community or from legislators sometimes that there's a problem on a site, project site in their district or in their community. And staff will go out to investigate whether or not there really is a violation. Because if it's something that can be rectified or it really is not a violation, we don't want to schedule a sunshine law hearing or meeting for the commissioners. These very, very rarely end up coming before the commission because if we go out and we discover that there is a problem, the petitioners are usually quick to rectify it. Or, and as in the case of Hawaii Memorial Park, well, we had a recent complaint. We went out there and we got a complaint from the community. So we went out to investigate it. And it turned out when we got out there that the community wasn't concerned about what was going on. They were concerned about something else. And the petitioner was able to work with the community to resolve the issue. I don't know if anybody has any questions with regard to site visit policy.
Commissioners, any questions about site visit policy?
Chair,
Yes, Commissioner Miyasato.
Chair, did we skip over item B?
Oh, I did. I'm sorry. I'm sorry.
Yeah, that was
No,
all right.
no problem.
I flipped the page.
Okay, yeah, anyway. In
I'll go
regards
back.
to, item C. Site visit policy. I was mentioned that, we haven't had a DBA for a while, so is site visits limited to DBAs?
So for example, could there be one for a special use permit, like the landfill?
There could be, but the general policy has always been just, we usually don't schedule site visits except for DBAs. They're logistically difficult for us, which is why we don't do them all the time. Because if, for instance, with a special permit, let's say it's a rock quarry and it's way back in the woods and you need a 4-wheel drive vehicle to get there. We have to arrange for a vehicle for the public as well as the commissioners. So logistically, they're not simple things to do. If the commissioners feel that it's necessary and the chair directs us to do a site visit on an SP, we will, of course, do that. But it's not something we do generally, especially with SPs, which tend to be down dirt roads and in the woods and difficult to get to.
Maybe this is a question for the deputy AG, but is there an exception for exactly those reasons, the difficulty of access?
If we're gonna ask any questions of me, we have to go into exec, so. Yeah,
If I can, Chair, there is not. I mean, there's sunshine law meetings, as far as I know. I mean, Deputy AG may tell me different after this meeting and spank me. But as far as I know, there is no exception. Since they are sunshine law, the public has to have access to the whole proceeding.
Thank you. I appreciate that clarification. And then, so then would a permitted interaction group, which overflows into the next agenda item, be one way for 4 board members, less than a majority, to be part of an investigative group to, let's say, to go do this special use permit site visit?
I would defer to the deputy AG on that because I'm not an expert on pigs.
Let's talk about that when we have our pig discussion.
Okay,
Let's talk about that when we have our
Sure.
pig discussion.
sure.
Any further questions on that?
Any questions? Any other questions on the LUC site visit policy? Oh, let's have a recess for 10 minutes. Till 10:03. Okay, we're going to continue with the executive officer's presentation.
Thank you, Mr. Chair, and I apologize for skipping over item B. I just flipped the pages on my notes and they were stuck together, so I'll go back to item B, which is a discussion of staff reports. And again, I would refer you back to the training session where this stuff was gone into in extreme detail. But staff reports are designed to be a synopsis of the petition. They are not a substitute for commissioners reviewing the file. They are intended, for lack of a better word, to be like cliff notes, pointing out the more salient issues that are presented by the petition. They do contain recommendations designed to point the commissioners to key issues and shortcomings, and they are intended to provide a basis for further questioning of the parties and discussion by the commissioners. Recommendations and conclusions are staff opinion based on our professional experience and our understanding of the petition that's presented to us. Commissioners ultimately, of course, make the final decision, and they are free to vote however they choose and even to ignore the staff recommendations if they do decide to do that. And one of the reasons that this happens frequently is because staff reports are based on the information that we have a week out from or more than a week out from the hearing, 2 weeks out from the hearing, because it takes a week to prepare them. Very often during the course of the hearing, and sometimes as a result of some of the questions that we suggest petition commissioners ask, things change. So if in the end the commission makes a decision that doesn't track the staff report, that's fine. You know, we're just trying to give the commissioners a leg up before they go into the proceedings so that they have some professional opinion on the issues that are of concern to the planners and to the legal staff. And Scott may want to go into some more detail on how he prepares them and how they are prepared. But once again, they are not the be all and end all, and staff is not upset if the commissioners don't adhere to their recommendations. The commission very often does get information at the hearings that may even render the staff reports moot, or the recommendations in the staff reports moot.
Well, before staff tries to get rid of all the blame, you know, it does carry some weight, right? So.
Well, it does.
Scott's going to.
Yeah, it does. But I think that the important point to make is that they're really designed for the commissioners' use at the hearings to help them develop the record and to obtain information that is relevant to the decision and fill in the gaps.
Aloha kako. This is Scott Derrickson, Land Use Commission Chief Planner. I mean, I have a lot I could provide to you about the staff reports. I guess I'll try and do it very generally, and then respond to any specific questions you might have. So staff prepares the staff reports prior to the commission's consideration of each docket. While one staff might be assigned to do the staff report, we do circulate it with the executive officer and other staff planners to get their review and input. Oftentimes, another planner may have history with a docket and be able to provide some context that the one assigned might not know or might not have. So the staff report attempts to summarize both the procedural history, identifying legal, technical, and substantive issues for the commission. Those summaries specifically cite to where in the record that information can be found. If you take a look at our staff reports, we often have a link that directs you, where did we get that information from? Where did that information come from? The staff, again, we don't make the final decisions. The commission is a decision-making body. When it's appropriate, the staff can provide and does provide recommendations, and we try to highlight issues that we believe are unresolved by the information that's been provided up to that point, or significant issues that we flag. The staff report's supposed to be an informational tool, as Dan said, to assist your deliberations. And the commissioners are expected and required to review the full docket record in addition to the staff report before you do your decision making. What we try to do in the staff report is make it a little bit easier for you to, you've all sat now through a number of hearings, motions. Sometimes, especially if there's an EIS involved, you're talking about thousands and thousands of pages of documents. So we try to do our best to summarize in a short, concise way, while also pointing you back to the specific areas that you might want to dig into deeper. Also want to indicate that, staff reports, they're not opinions by laypersons. They're representative of expert opinions by recognized and credentialed subject matter experts. That's what we are. That's what the LUC staff is. We're subject matter experts. And we've often been relied upon in court hearings and recognized as experts. If you look at the staff reports, the way we try to set them up, we try to initially set the context for what's the legal process that you're doing. Is it a declaratory ruling, and what does that mean? And what are the decision-making criteria that a DR process requires? If it's a DBA, we do the same thing. Here are your decision-making criteria that's laid out in Chapter 205, as well as in our rules. We also do a procedural history. Oftentimes, especially with motions, there's quite a history behind. So we try to give you the context, the original docket, what some of the issues were, what the conditions were set, and now this motion, what's that procedural history? We lay out the summary. We summarize the different parties' positions, as well as any public testimony that has come in. The staff report has analytical sections where we identify areas of concern. We identify any consistencies that we see. And that may be that a petitioner provides information about one thing, but we get something from the county, or we get something from the Office of Planning and Sustainable Development, or we might get it from the public. And if it's inconsistent, then we might raise that as an issue. We also do, especially with environmental impact statement reports or environmental assessments, we might talk about the level of completeness or compliance to conditions, because there is a difference with environmental impact statements and assessments. Okay, that's a disclosure document. When that gets translated into your proceedings for decision making, okay, there may be a higher level of documentation that's going to be required. And we have pointed that out in the past when we do a staff report. And I think I'll end there and let you guys determine whether you got more questions.
Thank you, Mr. Dirksen. Any questions at this time for Mr. Dirksen regarding the staff report process? Okay, if not, I'm going to turn it back over to Mr. Rodenker.
Thank you, Mr. Chair. Once again, a lot of what Scott talked about was talked about in detail at our prior training session. And I would urge the commissioners, if they have any questions, to review that. Moving on to item D, which is development of agendas.
Go ahead, Commissioner
We're
Miyasato.
gonna continue with more on that subject, so. So far as the staff report, kind of more the timeline, I guess, would be my question. I guess, a little bit more insight. I would kind of want to know, the county does their opinion like 2 days before the hearing. I noticed it being posted. Same with the state. You know, is there, I guess, a way for the commissioners to get their opinion a little earlier so we can review it and have some time to maybe not research, but I guess digest and maybe do a little bit of background checking on their specifics. We kind of cramming ya right now. So just curious if could get a little bit more lead time.
And do you have an answer?
Yes, and I have to empathize with Commissioner Miyasato. This is an ongoing problem that we have with the counties and with OP. I think OP is, we've discussed it with them, they're gonna get better. But we usually require their opinions and position papers to be filed with long before the hearing, but they don't. And then they show up at the end and 2 days before, and what are we supposed to do with it? I mean, theoretically, a late filing can be ignored by the commissioners. I mean, they can say, this came in too late, we're not going to take it into consideration, but has that ever happened? I've never really seen that occur. You know, usually if something comes in at the last minute, the commissioners say, oh, well, you know, okay, you know. But it isn't, I understand. And usually we're requiring everything to be in a month before the hearing, but they just don't do it. They just don't do it. And we get stuff at the last minute and we throw up our hands because there's nothing we can do about it. We have to post our staff reports a week, is it a week prior to, I think it's a week prior to the hearing? I don't know.
Sunshine law is 2 days prior to the meeting.
Well, 2 or 3.
2 to 3 days, whatever
Yeah.
the sunshine law.
Yeah, but we have to have it in the can a week before the hearing because that only gives us 3 days to sort out any problems before we then have to post it, which is 3 days before the hearing. And if something comes in at the nth hour, we try and, if we can, we try to put that in the staff report, but very often we cannot. But I really empathize with you and it is a frustration of staff. When we were doing district boundary amendments, when we had a lot of district boundary amendments some time ago, we would actually cancel hearings because something would come in at the nth hour and we didn't have time to analyze it. So I empathize.
Any other questions? Okay, thank you. Please continue.
Okay, so are we clear to move on to development of agendas? Okay. Item D is development of agendas. Our agendas are developed based on filings. We work with the petitioners because just like in regular court system, if the attorney's not going to be around or witnesses are not going to be around, we might have to adjust the hearing dates and have agendas for different times. But they're based on the filings. The wording is developed in conjunction with the attorney generals as to how a petition or an agenda item needs to be phrased so that it meets sunshine law requirements. Any other items are placed on the agenda per the chair. If a commissioner has something they want placed on the agenda, they can discuss it with the chair. The chair then decides whether or not we place it on the agenda. But that's pretty simply how the agendas are developed.
Okay, any questions regarding the agenda?
Chair,
Go ahead, Commissioner Carsmith.
thank you. Isn't it true that you, Chair, asked for an agenda item to be posted today? A training which would include protected classes and harassment. And this was not put on the agenda? He just made it sound like if you ask, then it's there. So I thought that there had been a request for that and it didn't come to fruition. So if somebody could explain, please. Thank you.
Yeah, I think in that situation, we had to try and work with the Deputy Attorney General's office, and I didn't heard back anything. Have you?
Yeah, staff is not experts on that, and neither is our Attorney General who's present today. It would take a special or a different division of the Attorney General's office to handle that type of information, or our Human Resources Department. Our Human Resources Department at Department of Business and Economic Development has indicated they're uncomfortable with presenting that to commissioners. There is all of us who work for the state, whether we're supervisors or non-supervisors, we go through several different training sessions on human resources, harassment, all of those things. And they didn't have a presentation that they felt would be appropriate for commissioners or that they were comfortable giving. But we have not heard anything back from the Attorney General's office with regard to any further training. So I guess the answer to the question is sometimes even if it's requested, it's not possible. You know, we do the best that we can. If there are legal reasons or lack of a better word, an inability to develop the right person to come and talk to us on an agenda item, we can't schedule it. And there are some agenda items that are difficult for us to schedule because we can't find a way to deal with them under the Sunshine Law.
Okay, thanks. Yeah, it's a continuing thing. We have to work with the Deputy Attorney General's office on scheduling some of these touchy agenda items. Any other questions?
Chair,
Yes, go ahead, Commissioner Carsmith.
it's not a very satisfactory answer. If the state employees are trained on a variety of things, as was just mentioned, I would think that volunteers on boards and commissions could be trained equally. And especially if we're subject to complaints, we should be able to be trained so that we are aware of the things we shouldn't do. Thank you.
I kind of want to stop this discussion at this point because I feel like we're veering too close to specifics with that last question. So let's please move on.
Okay, thank you. All right, sorry about that. Okay, we're going to continue. Do we have any more on the overview of processes for the maintaining content on the website?
Yes, Sheriff, if you want, we're ready to move on from agendas then. Okay, item E is website maintenance. And website maintenance is, there's not much to really say about it. Ariana and Martina and Scott in particular help to maintain the website, mainly Ariana. And she does a lot of work on it. Everything that we get in is put up on the website. Everything official. Sometimes we do post other things on the website that we think that the commissioners should know about, that they're out there. They're not our opinions. They're usually news articles or letters, things like that that we receive. And they're not in any way intended to drive a decision. They're just, you should know that this has been said, or that this article is out there. Website maintenance is, to a certain extent, is almost a administrative function. You know, we just do it. Ariana spends a lot of time on it, trying to make sure that everything is properly filed in the right location and under the right headings, and that it's ADA compliant. That's one of the issues we also have, is trying to do ADA compliance. I don't know what kind of other questions the commissioners may have with regard to that, or whether Ariana wants to go into any more detail before we move to questions.
I think you summarized it very well. I would say all docket related filings are automatically posted to the website for the commission to review. Everything docket related is public record. So, and they all have to be ADA compliant as well.
Okay, thank you. Any questions regarding the website content process?
Chair,
Yes.
this is in no way a critique to staff. It's more of the state. Can you explain why it says unofficial? It says unofficial admin rules, and a comment was made about everything that's official was posted, but why does it say unofficial? Kind of confusing.
Technically, the official rules are held in the AG's office, not the AG's office, the Lieutenant Governor's office. And any copy of that is an unofficial copy. So that's why we have to post it that way.
Okay, it just seems irrelevant when it says unofficial, like it's gonna become official someday.
No, I understand, and I balked at it a lot when I first started years ago. I was like, I confronted Scott at one point and I said, why does it say unofficial? And he gave me the answer that I just gave you. So I can understand the confusion.
Okay, so when
If you guys have any other like questions about rules and that kind of stuff, we should go into exec session because the state gets in trouble for unofficial, like actually unofficial, what you're thinking of unofficial rules a lot. So. I recommend we go into exec session real quick, just to answer his question.
Okay,
Okay, so we need 2/3 to approve going into executive session. Does anyone have a motion to enter into executive session to discuss our powers, duties, privileges, immunities, and liabilities?
I just had one more question on that.
Well,
Does he want to just ask it and then if he wants more explanation about this, then you guys can move. If I just want to stop what we're talking about that question.
okay, let's just chance it and see what
Okay.
what threshold we meet here.
On the website, it has 2008 unofficial rules, 2018 unofficial rules. Is 2008 moot?
You mean the old, there's two sets of rules, yeah. The 2008 rules, those are the old ones, right, Scott? Yep, they're just up there for reference because there has been some discussion with some petitioners' attorneys that, oh no, we did this in 2005, so those rules applied, not the new ones. Right, so we post them up there just so that everybody can see them. There's not a lot of differences. Most of the differences between the 2008 rules and our current rules concern the information that's required to be contained in the filings. But there's not, procedurally, there aren't really any changes in the procedural sections of the rules.
Okay, all right. Any other questions? Okay, seeing none. All right. Do we have anything more on this issue?
No, Chair, that concludes my presentation.
Thank you. We'll now have one last opportunity for any members of the public who wish to provide new or additional testimony on this matter. Is there anyone that would like to let the chief clerk know that they would like to provide testimony?
Nobody has used the Q&A feature to indicate they want to give testimony.
Okay, Ms. Kwan, are there any members of the public here who wish to provide any new testimony on this matter?
Seeing none in the room.
All right, thank you. The next agenda item is agenda item number 3, discussion on chapter 92, Hawaii Revised Statutes, HRS section 92-2.5, permitted interaction of members and permitted interaction group. Since the commission already learned about pigs on January 22nd, 2025, this agenda item will serve as a refresher for the commission and help clarify any questions that may still have been lingering regarding permitted interaction groups. All right, now we'll recognize if there's any written public testimony submitted for this matter. Ms. Kwan?
No, Mr. Chair.
Okay, there not being any written testimony, is there any member of the public who wishes to testify in person on this matter?
Seeing none using the Q&A feature, Chair.
Thank you. All right, we're gonna go now to the Deputy Attorney General, Mr. Dubio. Please proceed.
Chair, last time this was given, it was given in exec session, so I'm going to continue to follow that. So could you guys move into executive session, please?
Okay. Okay, it's been moved by Commissioner Kahele to enter into executive session for a discussion on this agenda item on permitted interaction groups. Is there a second? Seconded by Commissioner Uu. Okay. Oh, okay. Can someone else make the motion then if we're having a problem with that, with the microphone? Yeah, someone else. Yeah.
Second.
Okay, it's been moved by Commissioner Kelly, seconded by Commissioner Miyasato to enter into executive session. Is there any discussion? Any objections? Abstentions? Okay. Should we call for a roll call vote for this too?
You don't need to do that.
Okay, thank you. All right, let's go into executive session. Thank you. All right, we're back from executive session where we discuss some of our powers, duties, privilege, immunities, and liabilities regarding permitted interaction groups with our Deputy Attorney General. Okay, we'll now give one last opportunity if there are any members of the public who wish to provide new or additional testimony on this matter. If so, please let the chief clerk know. Ms. Kwan, is there anyone?
Seeing none in the Q&A feature, Chair.
Okay, is there anyone present who would like to provide new testimony on this matter?
Seeing none in the room, Chair.
Okay, thank you, Ms. Kwan. The next agenda item is item number 4, the adoption of the minutes. The next agenda item is for the adoption of the December 3rd, 2025 minutes. Ms. Kwan, has there been any written testimony submitted on the minutes?
No, Mr. Chair.
Are there any members of the public who signed up to testify on the adoption of the December 3rd minutes?
Seeing none in the Q&A feature.
Thank you. Commissioners, are there any corrections or comments on the minutes? Yes, Commissioner Giovanni.
Thank you, Chair. I was not in attendance at the meeting and I will recuse myself from this matter.
Okay, thank you, Commissioner Giovanni. Any other discussion? Any objections? One abstention from Commissioner Giovanni. Otherwise, we have unanimous consent on the adoption of the minutes. Or should we do a roll call vote? Yes, okay, let's conduct the roll call vote. Executive Officer Oro Denker.
I need a motion, Chair.
Okay, is there a motion to adopt the minutes of December 3rd hearing?
I'll make a motion to adopt the minutes for the December 3rd,
Okay, it's
2025 meeting.
Moved by Commissioner Wu. Is there a second?
I'll second.
Seconded by Commissioner Kaeli to adopt the December 3rd minutes. Okay. There's being no discussion. I think I'm going to ask now for the roll call vote.
Thank you, Mr. Chair. The motion is to adopt the minutes. Commissioner Uu,
Aye.
Commissioner Kahele,
Aye.
Commissioner Carr Smith,
Aye.
Commissioner Miyasato.
Aye.
Commissioner Hayashida,
Aye.
Commissioner Kamakeo Hello. Did I hear an aye?
Could you repeat? Yeah, thank you.
Commissioner Giovanni abstains. Commissioner Yamane,
Aye.
Chair Lee.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Okay, thank you. The final item is the tentative meeting schedule. This can't check out yet. Mr. Odenker?
Thank you, Mr. Chair. On our next meeting is scheduled in February. Right now, we are tentatively discussing whether or not we will be able to present to the commission on February 11th a presentation on legislation. But it depends on the final filing dates for most of the legislation. On February 12th, we are supposed to be in Kona for Honoipu Hideaway, but we did receive a request for an extension today, so that hearing may move. February 25th, we have scheduled to be on Maui for the Pu'unene Quarry. Motion to amend, that is probably going to move to March 11th. And then we will be scheduling another hearing on March 25th, if necessary, on that special permit. In April, April 8th, we'll be on Kauai for the Grove Farm motion to amend, but that is pending the motion filing. We have not received it yet, and that takes us through our schedule so far.
Okay, commissioners, do you have any questions for Mr. Odenker on the tentative meeting schedule?
Excuse me?
So the Grove Farm motion to amend,
That
what project is that?
A89636. I'm not sure what, we haven't received the motion yet, so
Okay, fine,
we're not
thanks.
sure exactly what they're talking about.
Okay, thank you. The next Land Use Commission meeting is scheduled for February 12th and will be held in Kona. Due to the location of the meeting facilities and the demanding schedule required to complete LUC business, I would like to request that meals be provided as a working lunch as an integral part of the meeting. Mr. Ordenker, would the LUC staff please make the necessary arrangements for the working lunch?
We will, Chair, thank you. But I caution again that we've already got a request to move that meeting, so.
Okay, thank you. All right, this next item is our adjournment. This concludes our meeting. Is there any further business to discuss? Okay, seeing none, this meeting is adjourned. Thanks.